Ginger Snap's been spending too much time with Common Joe, so we're going to go through this and try to unsnap the Ginger Snap from the twistedness of Common Joe. Merb, you're really trying to twist this one. Oh, I am I? We'll see about that. The whole point of what Johnny said is the police do not have to protect you. We're going to listen to what Johnny said. So this is heavy duty. This is a clarification because no one seemed to understand what I was saying, and no constitutional duty to protect, which is based on Johnny 5-0's New York Stock Exchange data center, in which he had this exchange with this person who is a security officer for the data center. We're going to take a quick listen to this, and we're going to see what Johnny says.
What they're doing here is they're just trying to protect everybody's safety.
Yeah, so am I.
They don't want you to get hurt either.
Yeah, no, actually, Gonzalez versus Castle Rock in Colorado, it's a Supreme Court case. The police have no expectation of our safety.
The police have no expectation of our safety. That's what Johnny said. Now, I am not a telepath. My third eye is closed, if it even exists. My chakras are out of alignment, and I can only go off the data that I have. Now, he listed Castle Rock v. Gonzalez. He has it on the bottom of the screen, somewhere there. There you go. There's Castle Rock v. Gonzalez. I know he did it wrong, but sue him, I guess. I don't know. So I have to go by what Castle Rock v. Gonzalez says. I'm assuming that he's trying to say what Castle Rock v. Gonzalez is saying because that's what he is citing. Castle Rock v. Gonzalez does not say anything about the police's expectation of our safety, whatever the hell that means. Castle Rock v. Gonzalez is about a constitutional duty to protect, either procedural due process or substantive due process, and whether or not the 14th Amendment grants a cause of action via 1983 lawsuits to sue the police if they fail to protect you. We resolved that very quickly and painlessly by saying that no, there is no cause of action. That's what the court is saying when they say duty. There is no cause of action granted to individuals if the police fail to protect you. South v. Maryland, however, that we went over, said that there is a duty to the public. And if the police fail to do their duty to the public, then the police may suffer from indictment. That is a duty to the public. That is not a duty to you. But you're a member of the public. So let's figure this out. Ginger Snap gives us an example here, so we're going to see. If someone breaks into your house and beats you and robs you, not only can you not sue the police, but we both know there will be no indictment for the police for failing to prevent that attack either. That is correct. There would not be. Because the police, like me, aren't telepathic. And the police, like me, have limited resources. They cannot be everywhere at once, just like I can't be everywhere at once, just like you can't be everywhere at once. Now, a real activist who thought that this was unfair, a real activist would take the words from Castle Rock, where the court said that the state could make statutes that would impose a duty to the individual on the police, and would then crusade to get those statutes put in place if you actually thought that those would be a benefit to society. And since you're not doing that, since instead you're complaining on the internet to me about the unfairness of it all, I'm forced, because of my lack of a third eye and my unaligned chakras, I'm forced to assume that you're not an activist. Snap. So, what is the duty that the Texas police would have? This is in the Texas Code of Criminal Procedure, Article 2.13, Duties and Powers. It is the duty of every peace officer to preserve the peace within the officer's jurisdiction, to the effect or to effect this purpose, the officer shall use all lawful means. The officer shall, in every case authorized by the provisions of this code, interfere without warrant to prevent or suppress crime. To execute all lawful process issued to the officer by any magistrate or court. To give notice to some magistrate of all offenses committed within the officer's jurisdiction, where the officer has good reason to believe that there has been a violation of the penal law, and to arrest offenders without warrant in every case where the officer is authorized by law in order they may be taken before the proper magistrate or court and be tried. It's also the duty of every officer to take possession of a child under Article 63.009G, subject to subsection E. In the course of investigating an alleged criminal offense, peace officer may inquire as to the nationality or immigration status of a victim of or witness to the offense only if the officer determines that inquiry is necessary to investigate the offense or provide the victim or witness with information about federal visas designed to protect individuals providing assistance to law enforcement on request made by a peace officer. Peace officer shall execute an emergency detention order issued by a Texas Civil Complaint Office under section blah, blah, blah of the Health and Safety Code. Subsection D does not prevent a peace officer from conducting a separate investigation of any other alleged criminal offense or inquiring as to the nationality or immigration status of a victim of or witness to a criminal offense if the officer has probable cause to believe the victim or witness has engaged in a specific conduct constituting a separate criminal offense. So those are the duties of the police. If the police officer sees a felony taking place, it is the duty of the police officer to preserve the peace within the officer's jurisdiction, and he shall use all lawful means to do so. If he sees a crime being committed, he will use all lawful means to preserve the peace. So if he sees someone breaking into your house and or sees someone beating you and or robbing you, he then is duty bound to act. And if he does not, then he will face the consequences for his breach of duties. Probably he will be fired, etc. Your explanation is educational. Explain the ruling just says we can't sue the police for failure to protect us. Yes, that is correct. You cannot sue the police for failure to protect you. Generally speaking, like I could always imagine a hypothetical where you could theoretically sue the police. Like if there was, let's say that you were a minority who moved to a small town in Boise, Idaho, and the sheriff idly leaned against a lamppost and smoked a cigarette while the townsfolk proceeded to lynch you, string you up, and kill you. Your family could probably then sue that police officer for failing to act under probably 1985, maybe 1983, but probably 1985. I think you could probably, I think a good attorney could probably craft something showing conspiracy to allow that crime to occur. But the point is still valid. The police have no duty to protect anyone. They do. They have a duty to enforce the peace. They have a duty to preserve the peace within the officer's jurisdiction. There's also the community caretaking function, which may take place or may be in effect in your state. The Supreme Court's had like 3 rulings on it, which have been tied to vehicles, but states and lower courts have had the community caretaking function meander far afield. But yes, if the police officers see someone attacking you, then the police have a duty to prevent that crime, or to stop it, I should say, not prevent it, because it's already happening. You're already getting beaten. But they have a duty to interfere. They have a duty to protect the public from breaches of the peace. So you're wrong, and well, no, pretty much you're just wrong. But thank you for playing Ginger Snap, and have a great day.